name is Emily, and you're going to hear more from me later. But we're going to open up with a pule from Devin, one of our speakers.
E holo malu kako, au he oe kamakua lani ko mako haku ko mako ho o la kamea nano ho I hani kalani me ka honua. O oe no ho I mamua ma hopi mana a paua mako nei. E no ho I mako ke kahi o kaupo e keiki ako ko mai ki ala. No ka wala au ana, ke kuka ana I ke ia kumuhana nui o kona koi o ka vai manao o ka poe Hawaii. Ke noi haha ani mako ia oe kamakulani e koko mai a mako. Na kanaka e kuka ana I kia mau mea me na kanaka e nānana nā naina nā nāno hoi. I kupu mai no I nā manao e pono ai a I oki ho o ka awali I na me e pono ole ai. A maka ho o kui o kia halawai ana e kamakulani e kia I alakai mai a mako I ko mako hoi ana. I hoi ano hoi mako I ko mako wahi e pono ai. Te lele o kia ka mako leo pule vai hui I mamu au. Maki no kau keiki hivi Jesu Christo ko mako haku e olai. Amene, amene, amene. Mahalo.
Okay. Aloha mai kako, and welcome to the Intellectual Property and Indigenous Knowledge Talk Story hosted by the Asian Pacific Law and Policy Journal and Native Hawaiian Legal Corporation. My name is Corey Palencia, and I am co-editor-in-chief of the Asian Pacific Law and Policy Journal. We wanted to have this conversation today to increase awareness and further discussion around how Indigenous communities, including Native Hawaiian communities, may use intellectual property legal system to benefit and or protect their culture, knowledge, and traditions. So our conversation today will begin with our journal's other co-editor-in-chief, Emily Walker, asking a few questions to our panelists, Makalika Naholowaʻa, Executive Director of Native Hawaiian Legal Corporation, and Devin Forrest, 3L here at the William S. Richardson School of Law and Akumuhula. Beginning with our first panelist, Makalika Naholowaʻa. Makalika Naholowaʻa began serving as Executive Director for the Native Hawaiian Legal Corporation in December 2021. Before starting at NHLC, she was an Assistant General Counsel at Microsoft Corporation, where she worked for 8 years and led teams across multiple roles, including Chief of Staff for the General Counsel. Makalika also previously practiced within the Intellectual Property Group at Perkins Coie LLP in Seattle. Makalika's past work on Indigenous justice includes nearly a decade of leadership roles with the National Native American Bar Association and work as a legal clerk serving Tanya Gonella Fritchener, a former North American representative to the United Nations Permanent Forum on Indigenous Issues. She has written, spoken on, and advised frequently on intellectual property and traditional knowledge issues. She is a lifetime member of the Native Hawaiian Bar Association, and Makalika is a Haumana Ho'oponopono studying under Kumulenet Paglinoan. Makalika studied law at Columbia University and mathematics at Arizona State University. In addition to her work for NNABA, in service to the bar, Makalika has held leadership roles with the American Bar Association, Washington State Bar Association, and the International Trademark Association. Boko Makalika. To our second panelist, Devin Kamealoha Forrest. Devin Kamealoha Forrest was raised in Ha'ena by his maternal grandparents Francis and Kopeka Chandler. This Hawaiian household gave him an understanding of culture that could not be obtained through schooling alone. Devin grew up around Lawai'a, Mahi'ai, Ha'imo'olelo, and of course Kumuhula, who instilled in him the importance of every aspect of Hawaiian culture. He also went through the process of uniki under Kumuhula Lehua Matsumoto, attaining the rank of Kumuhula. Along with his cultural training, he has also completed an MA in Indigenous Language Revitalization, Hawaiian Language and Literature from Kahakaʻula o Ke'elikolani College of Hawaiian Language at the University of Hawaii at Hilo, giving him the academic training to both teach and expand his understanding of Hawaii's language and culture. He's currently a JD candidate at the William S. Richardson School of Law and will use this legal training to help expand protections for Native Hawaiian knowledge. Devin's personal vision is not only to perpetuate and preserve Native Hawaiian culture for the betterment of the Hawaiian community, but to establish a standard by which we can use our collective past to bring forward an expanded vitality to our present and future, one that is grounded in the wisdom and knowledge of our ancient customs and practices. So again, mahalo nui for talking with all of us today and for sharing your ike and mana'o on IP and Indigenous knowledge. Just again, as a housekeeping, there'll be around 15 to 20 minutes at the end of the presentation where all participants will be able to join in the discussion and ask any questions that you may have. So without further ado, please welcome Apple PJ's co-editor-in-chief, Emily Walker, who will be moderating the first part of this conversation. Mahalo.
Thank you, Corey, and thank you everyone for being here. Please remain muted for this first part of the conversation. So I wanted to start this off with a question from Makalika. And just as so we have a lot of different people with different backgrounds that are here participating in the talk today. So I'm hoping you could just tell us a bit about how the intellectual property system works generally.
Sure. Thank you so much to everybody for taking the time out of your day. One thing I just wanted to do a shout out quickly. I know we want to get onto the IP stuff, but just want to celebrate with this group. 2 reasons. One, for the first time since the pandemic, the Native American legal community is getting together in person right now in Albuquerque. So I'm dialing in from a pause on that conference to be with you. And it's just so wonderful to be able to spend time with people again. And I hope that one day soon, you know, groups talks like this can be in person again too, so we can connect. And also just want to celebrate that we've got our first ever African-American Supreme Court, woman African-American Supreme Court Justice. So that is truly, it's truly a historic day. And it just feels like a day full of possibilities for people of color. And I'm excited to see what she does on the court. So good question about the IP system. So I think one thing I would say, if you're interested in intellectual property and you haven't had the opportunity to take any coursework, fully recommend going on the internet and doing some 101 trademarks, copyrights, patents kind of searches, because there's tons of great primer videos out there. I would say in a nutshell, because I think in this conversation, we really want to talk about, you know, what are the challenges in the system, the differences between Indigenous thought when it comes to creative expression and invention, and identifiers of organizations and people. You know, I would just say, like, we're not going to get into the nuts and bolts of the IP system unless you ask me a question in the Q&A, but there's great 101 videos out there about that. At the highest level, what I would say is the IP system is about finding a way, you know, kind of through the Western American lens, for striking a fair balance for creators, inventors, and people participating in the economy, in the trade of goods and services, between abstract, non-physical things like content, and methods around how inventions are made, right? It's trying to incentivize people to create that kind of content, contribute it to society because of the value that it can provide, but do it in a way where they also get fair compensation so that they're incentivized to engage in those kinds of activities. Which right off the bat, you could quickly see some differences with the way that I think a lot of Indigenous communities would think about it, because the idea that you have to even have an incentive to create, I think, just seems odd to a lot of Indigenous ears. But that's really what it's about. It's saying, you know, when people hear the word copyright, we're talking about creative expression. So, you know, that's songs, that's art, that's, you know, that could be paintings, sculptures, things like that. When you're thinking about trademarks, that's things like you're identifying who you or your company are, right? So those are your logos. That can be the look and feel of your product, which can also you know, embed creative expression. So you start to have a little bit of a, you know, both trademark and copyright aspect maybe going on there. And then when you talk about patents, you're talking about inventions. So you're looking for original, novel, useful inventions, which in the Indigenous space, people are often the most focused on, you know, not necessarily things like hammers and toasters and things like that, which I think are like the most accessible examples of patents. But, you know, patents also includes inventions around medicines, strains of different kinds of plants, which has been a huge concern for Indigenous people, and continues to be today, use of genetic material to create therapies. So that all falls within the realm of patents as an intellectual property too.
Thank you. And then branching off of that, I'm hoping Devin can talk a little bit about traditional knowledge generally and provide some examples.
Okay, so when you had that question to me, I had to try and like think about something that could help with this, because like traditional knowledge, everything Hawaiian, yeah, that doesn't work. So I narrowed it down. Maybe somebody said this before me, but I don't know. It's the 3 Ps: practice, procedure, and product. So, and products maybe. So practices, we have hula. Hula is our practice. La'aulapa'au, that's our practice. Procedure. So this is where it kind of gets, la'aulapa'au, we have our practices of pule and how do we do things and collecting plants. But that isn't necessarily strictly Hawaiian plants. We have evolved in a way that we use other people's plants, because why not? If it works, it works. And so the procedures of our practice, that pule and collecting of the plant, whether it be Chinese, Hawaiian, whatever, that is what makes it our traditional practice. That procedure of the practice is what makes it traditional. And then the product, we have our medicines, we have our kalo, because the practice of mahi'ai, of farming, is not just, we plant the plant and then we get the food. We plant it, we look at it, we understand how it grows, and then through the procedures of cross-pollination, the product is our kalo, a new form or another form. So that's kind of how I finagled it around, yeah. And then going back to what Makalika said, that the Western idea is about this economy. We want to go and buy, sell. We need to be able to get money. Whereas what I think of it for Native Hawaiian, for Indigenous knowledge, it's more of a mana economy. That's what I think. Maybe I'm the first one that talked about it. Who knows? If not, then I'm borrowing whoever's one it was. Kalamai. I always say cite your sources, but when I wrote on Pepa, I never heard mana economy, so we would just talk with that baga. And so that's kind of what it is, in pre-contact Hawaii, the ali'i owned everything. It was, he owned Na'uoluna Na'uolalo. That was one of the Olelo No'eo that are attributed to ali'i, that his is above, his is below, that whatever was in Hawaii belonged to the ali'i. And so there was no economic gain from some of these practices like hula and hakumele. That all was dealing with mana management. You get this mele from a dream from one of the akua, so you would have to maintain and protect it because of the mana that mele entailed. So that's kind of what Indigenous knowledge is. It's like the flipping of throwing out our understandings of this IP system that we are currently in, and thinking about how was our knowledge managed, and what is our knowledge, and what is tradition. And so that's like the 3 Ps. Yeah, you have the practice, and then the procedures with that practice that keep it traditional, even though you're using new plants or stuff like that. So hula is still hula as long as you're doing the hula procedure. And yeah, so I think that's might be a little bit too much, but I know that's my problem in law school, is that we had everybody's about distinct definition. In Hawaiian, it's like we have 27 meanings for this one word.
Here at the Indian Law Conference happening right now, at lunchtime, we honored Professor Pombertime, who I think it was 35 years he taught at the School of Law in North Dakota. And one of the things that he's really known for is integrating poetry into his classrooms. And part of it is because he's setting that expectation that Indian law in general is just not linear. Like it's just not this easy scientific, like Western science anyways, like compartmentalized linear thing. And so that theme definitely carries through into this conversation about IPV traditional knowledge. So Devin, I feel like totally consistent with what I'm talking about with, 600 other Indian lawyers right now in New Mexico.
Thank you. And just to branch off of that conversation, Makalika, could you talk about ways that intellectual property could potentially intersect with protecting or other uses with Indigenous knowledge?
Sure. So one of the things that you think about the intellectual property system, it's about privatizing these abstract, non-physical elements of property. And there's rules that you have to, or requirements rather, that you need to meet in order to even qualify. So one of the things that someone has to think about, whether they're Indigenous or not, right, in any context, is whether or not they meet those rules. And often what those rules across, one easy rule that I think carries through all intellectual property is it basically has to be something that you've contributed, right? So something that you've sort of inherited through your discipline, right? So for, I think, Hawaiians, like, you'd be thinking about things that you have been passed down through your kumu or through your family, depending on who, like, where that expression in the case of copyright, for example, originated, it might not be eligible for protection. So that's one question. But the other thing I think the Indigenous person has to think through is, from a cultural perspective, is it pono? Is it appropriate to try to monopolize that as your own thing? And I don't have actually an easy answer to that. Sometimes I'll say, like, I'm just a lawyer, right? So that actually is going to really depend upon the discipline. And I think Devin, has already kind of touched a little bit on this, but should definitely talk a little bit more. His example of, you get a mele in a dream that you attribute to an ancestor. I don't know if it would feel appropriate, even though you might be the first living person to ever fix that mele into a medium, which then might mean you can register it and treat it like a copyright that you own, and license it, and prevent other people from using it. Do all the things that you can do with something that you own a copyright to. That might not feel appropriate, though, because of the other realms that you're considering as an Indigenous person, or because of other rules around what's expected of the things that you create within your discipline. Or maybe the complication with how do you even claim the thing that you've contributed, which might qualify for protection within the IP system, but how do you distinguish that from what you've borrowed from the community's traditional property, right? These things can be difficult. So, that's probably part of why I'm not personally aware of a lot of Native people leveraging the IP system. So one of the things that I'm an advocate for is more study around Native Americans' use of the IP system across the board. There's definitely studies out there that talk about, the underrepresentation of women within the patent system. So, the Patent Office has done some work to analyze, people listed as inventors, what percentage of inventors are women, what percentage are different people of color. But I'm not sure that we've got good data on how Indigenous people, not only Native Hawaiians, but just like Indigenous Americans in general, are using the system. And then once you've got those numbers, like, what's the reasons behind that? I think part of it is that there's some really, there's some issues that I just talked about in terms of what's the right thing to do with the knowledge. I think there's also issues with access to the system too. So I think it's entirely possible that there's many creators and inventors and entrepreneurs within Indigenous America that would be delighted to use the IP system, at least in parts. But I think there's also issues around having access to counsel. Culturally competent counsel is actually really important in this space because, as you can imagine, for the lawyers on the call, when you've got cultural practitioners, this is already asking, you can tell from this conversation, it's already asking them to think really outside of their normal worldview to leverage this system. And there's lots of challenges that our community is already going through, figuring out, like, okay, how do I manage all these differences while participating in this economy? So, I think there is a community out there that would like to access it because they are having to figure out how to make it in this economy, and it is requiring adaptation and change. But having access to affordable, culturally competent counsel is a huge problem. So one of the things that I've said for years within the legal community is, when I speak, I have often said, I'm the only Indigenous identifying American trademark lawyer in the country. And I've said it really loud and frequently because I keep hoping that somebody will say, you're wrong. I know about this person and that person and that person, because I know I can trust my lawyer community to tell me when I'm wrong. So I've consistently done this because it's hard to prove a negative, right? But I have been in spaces where I would expect to have seen it if it existed. And I'm aware a beloved colleague that I've worked with before in New Zealand, she's a patent and trademark lawyer. She's Maori. I think she was the first and might still be the only in New Zealand. I'm aware of one in Australia. But anyways, I actually said, well, what is this? I'd love to actually know more about what is this problem about access to accessible and affordable counsel. I know it's the case, but I don't know how to really quantify it. So a couple weeks ago, I made a post and I just put the list down of all that I'm aware of. So IP has all these different sections. Some people practice all of it, but actually most people don't. They'll practice some part. Traditionally, like typically you'll see people who go deep on patents and inventions. That's a really technical aspect of IP. A lot of times the folks that are doing that are not doing the other kinds of IP, but there's exceptions. So long story short, I made a list and I wrote down everyone I knew who identified as Indigenous and did some form of IP work. Not necessarily with Indigenous people, just at all. And there's easily 50,000 IP lawyers in the country. I was only aware of 6 when I wrote that list down, 6 out of 50,000. And then as I posted that and I started cross-posting it on all these different LinkedIn groups that I'm aware of that like lawyers congregate around, like there's a trademark professionals group on LinkedIn. So I started spreading it around, asking people to reshare. I wouldn't say it went viral, so I definitely encourage people, if you're willing to help me out on this, like go reshare it, help me like kind of shake the tree and see if some fruit can fall out. I now have, I think, 14 people on it. But still, you think about this, like you've got 14 lawyers amongst a bar of 50,000. We've got over 560 federally recognized tribes. Like access to culturally competent and affordable counsel is a huge problem. So I would just point out that some of the issues around IP and traditional knowledge are because the systems are in some ways really in conflict and not compatible. But some of the issues are that we don't have affordable, accessible counsel.
And just to like go off of that too, it's also the complexity of the culture. Everybody wants to just put Hawaiians in like this is the Hawaiian IP law. It's like you can't do that because the 3 Ps, the practice has different procedures, and therefore there does exist a IP system in Native Hawaiian and traditional knowledge. Each practice has a way of maintaining and passing on knowledge. That is intellectual property protection. There a great article I read was it's a transcription of a speech that Mary Kavena Pukui gave at Kamehameha schools, and she talks about how as kumuhula, when you're going through training, it's you have K, which are the kumuhula that come to the halau and are the outside judges that go and judge your hula and say if your students are prepared or not. But in the case that a kumuhula comes and watches your hula and takes it, and you observe that there are pule that you pray so that kumuhula either forgets or their haumana trip and fall, or all types of kinds of like I said, it was mana management. It was the protection of mana. It wasn't because of the money of the hula. It was because the mana that she or he put into that creation is being diminished because of that other kumuhula. So there are many instances in which, and we still do that today. We kumuhula that are on this call. I know you guys, when you're watching, like, oh, that's so and so's motion for ua, and that person didn't learn from them. They exist. The whole the respect though is, I think, because now that Hawaiian knowledge is going outside of Hawaii, that people who are not raised with this innate procedure of the practice, that now that's why we have this problem. It's people are just taking because like, oh look, that's pretty. I'm gonna just halau hula or YouTube, mahalo kumu, http www.youtube, and are using it. So, and that's kind of like, now we have to actually take part in the Western system, because we may not want, is like, we don't want the money. What we want is you to stop infringing and diminishing the mana that is hula, that is la'aulapa'au, that is our inoa, that we just want that to stop. And so I think that's also a problem with the Western IP. It's like the whole idea of damages and stopping, like, well, you really aren't damaged. because, you know, there's no monetary damage. Like, that's kind of what everybody's like, well, you're not, nobody's hurting you. You know, they're dancing in Timbuktu. It's not affecting you, but it does. The mana is being affected, and that should be able to be a quantification for protection of IP. Just went that way.
I think it's so complicated too, and part of it, like, this is, you know, I feel like everything you're sharing, it's a call for more people in this space, because, you know, I joined NHLC in December, so I went from being in a practice where I thought about these non-physical assets for more than a decade. That was like my everyday, and in an environment where actually, like, everyone around me is really focused on traditional property, right? Real property. But what's interesting, like, with the 5 months that I've had doing that, that was a major undertaking. And I think because it was so physical, people fully appreciated, and were probably just forced to really absorb how complicated it was to merge these two worldviews around the use, management, and monopolization of a real property, two different real property schemes, right? So two schemes colliding on the same lands. And it, you know, NHLC has been busy for almost 50 years now, and I don't think we'll ever be done on these issues, right? And so the complexity and how long it takes and how many people need to be involved to find and help the Hawaiian people adapt and find that, you know, Pono way forward, which sometimes doesn't feel Pono, right? But at least, like, on the end of the Native Hawaiians, you know, feeling like they're operating in a Pono way through the challenge. You know, that's been a multi-decade, multi-generational work in process. So one thing, and I don't say it to I say it to inspire people to get on the journey, not to discourage folks about how long the journey is, but there are some analogs. Like, the intellectual property system was launched off of concepts of real property, right? So I think it's fair for you to conceptualize the enormity of that journey similarly to the enormity of what it meant to make this journey on the real property system. Now, I think we could be accelerated because we learned a lot about how we're different with the real property system, and some of the challenges. But I think going into that with that mindset, I think one of the things that can be a real challenge in the intellectual property space when you're trying to counsel groups through it is, I don't think that, like, how complex it is so obvious. And so it can be disappointing. And then when you add in the expense, which I think actually the part of this discussion is a call to action, and other discussions I'm having right now in other Indigenous communities, it's a call to action to say, look, you know, organizations like NHLC were funded because we understood that individual Indigenous people were not likely to get justice if you expected them to just go about without programmatic, you know, legal aid organizations like NHLC. I suspect it's the same with intellectual property, you know, as you're talking about creators. And so there's a couple of exciting projects I've heard to support communities on the continent, of artists managed through abuses to their art and traditional knowledge online, that are being set up kind of similar to the way an NHLC is set up, where it's set up like a legal aid program. And so it's funded, and that's taking down some of the cost barriers. It's also like aggregating those clients into one team so that they can gain that competence on not just the legal issues, but also the common issues, common questions with that community. So part of what I hope this inspires people on the call to think about is, how are we going to recognize the complexity of this transition for Indigenous people, and just the way that we had to figure that out and create programs, not just tell people go fend for themselves with land rights. We realized, like, you tell that, like, the land's gone, right? And that, of course, did happen for lots of people. And eventually we started to realize, oh wait, no, we got to set up organizations, we got to set up programs, they got to be funded, and that's how we're going to support people into adapting to this system. And I suspect it's going to be the same for IP, or it won't be, and that'll be pretty tragic, actually.
Thank you. Just going off of that and how you both were talking about, kind of thinking about, well, Devin was talking about being pushed into the Western system out of necessity. And then we moved on to complexities, but I'm hoping you can talk a little bit about past uses of intellectual property, if any, so that you can kind of learn moving forward, or if anything has come out of that?
Well, historically, so besides the traditional, post-Western contact, there was actually in 1860 something, during Kapwaiva, we had an intellectual property law in the kingdom. It mimicked the U.S. system, the same verbiage in the, what was that, Clause 8 of the Constitution, where the copyright clause. So it's the same kind of verbiage and stuff like that, with a little bit of addition of if you write in Hawaiian and you're not in Hawaii, then you can still claim property. So it was very language based here and there and stuff. But the only case that ever was brought up or was talked about was Kamakau against I forget who. But other than that, there wasn't really as much IP issues that came up during the kingdom, and then territorial stuff. There was like copyright things dealing with Honolulu Advertiser, blah blah blah, but nothing dealing with traditional knowledge, mainly because if you think about it, 1830, 1820, Christianization of the kingdom, mana management is thrown out the door, because it's like, we do not, people are still maintaining hula, lua, all the pagan arts in their own little communities, but it's no longer a state protection. The ali'i, besides a couple in secret, are maintaining that ike, and you have it you have mele being posted and stuff like that in newspapers, but mele isn't seen as much as pagan as the practice. So you have all these. There's discussion. I wrote with my sis on this, so that's why I have all these discussions that are happening through the newspapers about this isn't pono, this is wrong. And so again, the community is policing what is proper and what is not. It isn't the state. The only thing the state is doing is, you can't copy my book, you can't translate what I wrote in the newspaper then make money off of it. So again, there's the divide between the two IP systems. It exists, but it's not, one is community enforced, the other is the state enforced, and then we get to the illegal overthrow and everything, and here we are today, still with trying to merge the two so that we can keep the integrity, because we can't trust other people that's not Hawaii to be integral, be pono. That's it. I was like, what is the word? Pono is the word. There's only one word for it, pono.
And the differences in the IP system are also reflected in the differences in the economies, right? It's just very different economies. So the IP system, like the economy came first, Western economy is established. They're thinking around, how will the economy work? And then the IP system emerged around it, right? To match those sensibilities of the community that really nurtured and built the system. And so when you think about Native Hawaiians, I mean, even just the idea of monetizing, right? Like in modern, so I've had experiences in the last 5 years where it's a recurring theme, that this whole even idea of monetizing creative expression and traditional knowledge, it's just still a miss. So before you even get to the complexities of like, what's pono to own, what's like, who owns what's community versus maybe an individual practitioner. So like all these complexities to try to see how you get rules to be compatible. Even the highest altitude ambitions between these two systems are different. I have now learned to look when big companies talk about how they've collaborated with Indigenous people, again, not talking just about Native Hawaiians, kind of in general. I have started to ask, did you pay them for their consultation? Did you pay them for whatever it is they contributed for this project? Because now it's become, I feel like in the last, maybe it's last 6 or 7 years, there's a big focus on cultural appropriation, which is kind of like, you don't have an IP right, but we're going to call policy foul, right? Cultural appropriation has become, you could also have an IP right, but if you don't have an IP, it's like, if you don't have good law, argue policy, right? Like that was one of the things you get taught in law school. And it's kind of like cultural appropriation, it kind of, for me, feels that way. It's like, I don't have an IP claim, but cultural appropriation, it's a policy problem. So one of the things that a lot of organizations are doing is they don't want that. They don't want that negative press. They don't want that. And maybe some of them actually want to do the right thing. And so they're going and they're asking for consultation and permission, and they want it to be authentic, right? And that's part of also what they're trying to do, the appeal of the authentically Indigenous experience, whether it be a video game or a piece of clothing or whatever they want. That's part of the value actually for them. So it's not just like a defensive action, but it's also part of where the value is. When you know there's a value, though, I will say, like, this is why I try to be a proponent of choice for practitioners, because when there is that value and I see a body of people struggling in modern economies to thrive, that value is why you get intellectual property rights if you feel good about it, because that's a licensing opportunity. But anyways, so one of the things I have learned to ask is, are you compensating? And usually they're not. And I have heard multiple times, they said they didn't want to be paid, right? And then people that are from those communities are thinking to themselves, yeah, because it's a gifting economy, so they wouldn't ask for that. They would expect you to know that you should make a gift back to support their tribe or their community, right? And so these misses are happening, and you've got, two communities, and I would say one, I always want to be in the spirit of, working together and having solutions. But one of the things we're going to need is the more empowered side of this equation to try harder. That is one of the things we're going to need. It's not going to be all about more of us going to law school and focusing on IP, and then doing all the work to try to stand up nonprofit legal service organizations that provide this and train all of our cultural practitioners and yada, 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 right? The list of things that we're going to have to do is quite long, but we're also going to need the other side of this equation to try harder to reach us, somewhere close to the middle. And part of this is you really thought that you came and you were selling a clearly commercial product at scale. You went and sought out, Indigenous culture and knowledge because of the value that offered, both protectively and affirmative value in the market. And you really thought it was, they were just happy to give that away. Meanwhile, you're in their lands, you're seeing that they have needs. You really felt good about that? Could you have asked anybody, literally anybody, about what would have been the right way to engage in that? So I guess what I'm sharing with these stories is there's also issues there. There's issues about we do need to have people within and outside of the IP system also continue to say look, this is going to be an economic thing, this is going to be a technical thing, but it's also going to be a heart journey, and you're going to need to try harder to do the right thing.
Thank you both for talking on that. I just was hoping that if either of you can talk on this, we could discuss a little bit about any examples of successful models, either of those types of relationships that you were just talking about, or communities successfully, I guess, defending their practices against appropriation. So just, I guess, let's start with that. If you know of any examples of successful models.
I heard of the Maori. The Maori are doing pretty good. And then I was reading an article about Duke did that. They went around a couple of models, and it's what Makalika said. It was the other side actually being proactive and being oh no, this is how this community works. And so that's the only ones that I know.
Yeah. Sorry, Emily, were you asking programs that have worked or legal schemes that are promising, or both?
Both.
Yeah. So there is an organization called the World Intellectual Property Organization, and they have groups focused because they think globally. If we got over 560 distinct Indigenous peoples within the United States, I don't even know what the number is globally, but it's an intimidating number, right? So they've got a formidable challenge ahead of them. But the good news is they do have a group focused on that, thinking about what should policy and rule changes look like. So one of the things about the IP system is there's enough diversity of rules from country to country that it keeps plenty of IP lawyers gainfully employed. So I wouldn't say that it's fully harmonized. The differences keep a lot of people housed. But at the same time, a lot of the principles actually are largely harmonized. And so the World Intellectual Property Organization being focused on what are the themes of needs across Indigenous people and thinking about how to influence the system is really helpful. So people who have a passion for learning more about this should go check that out. They actually offer a course on traditional knowledge and IP, and I think it's $300, and it's virtual. So that's a resource that I would spotlight for people. But I don't know that, we're far from an answer that's going to resonate and to Indigenous people generally and address all these things that Devin has raised that might seem Native Hawaiian centric, but similar versions of these issues exist across in our thematic. So there's been calls for sui generis forms of intellectual property because none of the existing forms really address all these needs. I don't know how to think about how practical it is to, I would not tell a practitioner to hold their breath, right? Like if you're trying to figure out how am I going to put a business model around what I do so that I can do what I do as my full-time job and, have housing and education for my children, I don't think you're waiting for a sui generis form of IP to emerge. I think pressure though, to figure out how do we get at least more competence around making sure that Indigenous communities are being weighed in new rules that do emerge, in the US, around the world. That's a good thing. I think helping IP professionals understand it so that they can use existing rules to their best advantage is helpful. So for example, a lot of times when people are doing deals, like the stories I just shared, consulting with traditional practitioners, it'd be great if lawyers were familiar enough with these issues to say, hey, heads up, these people might have a gifting economy. Just think about it. The lawyer can't tell you what to do, but the lawyer might say, look, normally when we do these kinds of deals, there's usually a royalty paid. It's not uncommon in Indigenous communities that they would waive royalty because it might not be culturally appropriate for them to essentially sell you their knowledge. That might actually be in conflict with their value systems around the knowledge. So they might be willing to share it, but they might not be in a position to quote unquote sell it to you in the form of a traditional royalty. Like you should think about these other ways, so that you're doing the right thing, right? These are things that lawyers can do. Lawyers can absolutely opine on these things. Doesn't mean you can tell your client what to do. You have to tell them the truth about whether or not the law requires it. But this kind of practical advice is really common. That's usually what separates the great lawyers from the average ones. So that's part of it. But part of it is also just getting creative about how the law actually applies. So, Native Hawaiian community was really upset about a company on the continent that was trying to monopolize the name Aloha Poke, right? So I think everyone in Hawaii has heard about that one. What legal theories currently exist? One thing that I'm curious about, because I've actually been confused as a consumer many times, is, has anyone ever studied the risk of consumer confusion when Indigenous languages are used commercially by not Indigenous owned organizations? Right? So there's already unfair competition law out there that says that you can't engage in false and misleading advertising. And I can't tell you how many times I thought I was supporting a Native Hawaiian organization and then later found out I wasn't. So I feel like I was deceived.
Yes.
So that's, and that might not have been in your intent, but intent isn't required for you to be in conflict with these unfair competition. Intent definitely hurts. If you do it intentionally, that is not helpful for your case, but your intent to mislead me is not what's required. What we're looking for is that you not mislead or deceive consumers. So there's consumer protection law out there, and I don't know that it's been tested or analyzed or even thought hard about. And on the trademark front, with some of these terms, there is a question, have we really pushed on how distinctive these terms are? So there's just a lot going on here, and what happens next is not a list of action items for any one component of this ecosystem. There's things that practitioners are going to have to do, members of the Hawaiian community are going to have to do, institutions that take it as their kuleana to safeguard our culture are going to have to figure out a way to step up and participate. But the IP system, the government system, is going to have to figure out what to do. There's probably some work on the AG side because they enforce unfair competition and consumer protection laws. There's just actually a lot going on here, and at the same time, not a lot going on, I think, right now. Just a lot of discussions about concerns.
One of the questions we got in the registration sheet kind of branches off of that, and it's what sorts of changes would be required to make it possible for Indigenous people? So we were talking a lot about what other organizations need to do and lawyers and businesses, but what would make it possible for Indigenous people to prevent undesired uses of words or their languages, just kind of how you were talking about aloha poke.
Yeah, what you just said. That's like that's the thing, coming up with those legal theories to go in, because like you said, I didn't even think about that. I was just like, you just can't do it. But you can't, that's not a legal theory. But yeah, like, the consumer protection, like, that's exactly it. I went to a place in Iceland called Mahalo Acai Bowls, and I don't think any Hawaiian went to Iceland and lived there because she's cold.
Yeah, and context is everything, right? I mean, in these kinds of cases, context really matters. But I mean, I think that the current state, I mean, I think we all, at least in the Native Hawaiian community, we're all hoping for a future for Olelo Hawaii that is bright, where it is ubiquitous, where the fact that someone's speaking Hawaiian in Hawaii doesn't really necessarily tell you anything about their ancestry and their relationship with the Native Hawaiian community, because that's just how pervasively it's spoken. And then at the same time, when I look across Indigenous languages, and let's not even necessarily use Hawaiian, like we could use any of the languages, right? In general, Indigenous languages in the United States, because the history of genocide and oppression and the policy of assimilation for Indigenous people, the reality is almost all of our languages are being desperately pulled away from the brink of extinction, right? So when someone is speaking these languages, it's rare that the person using the language isn't like affiliated or related, right? So like maybe you're not associating as Native Hawaiian, but your spouse is, and you've learned it because in your home, that's what you're trying to pass down to your kids, right? So there are exceptions, but in general, like that's where we are with the language. And so, it's a difficult topic, because I think what that means is commercially, people do reasonably expect that when they see Native languages being used, that behind that is an Indigenous business, an Indigenous creator. And honestly, I kind of call foul when people say that that's not what they intend to do, when it's not true. Because the whole aesthetic, usually in those businesses, everything about the way that they're marketing themselves tends to create that impression. And guess what? I've been confused many times, right? And so like we should do some studies on this, because again, it's not to call someone a bad guy. I mean, it's not saying that that's your intent. Although, like I said, when I see that full aesthetic and everything about the marketing and everything about like the way that the About Us is written and blah, 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 when everything is basically evoking that cultural context, I do kind of call foul on the idea that you're not trying to create that impression. But whether you are or not doesn't matter, because the intent isn't required. The fact is it's confusing consumers, and so that's an issue.
I don't have any more questions, so I'm thinking we can open it up with the last 10 minutes. Unless Devin or Makalika, either of you have any closing remarks that you'd just like to share.
I'll let them ask questions if they have a question.
Okay, just use the raise hand function, participants, to indicate if you have a question or not, or would like to join the conversation.
I never shy away from using my talks as opportunities to like use my audience as a focus group. If people don't have a question, I'd love to hear anybody's reaction to the idea of, do we need some kind of legal aid program to allow Indigenous people to get counseling for their IP needs? Like, do people in their lives see that as a need? Sierra has her hand up.
Feel free to unmute.
Hi, this is Sarah Cons. I am not an Indigenous person, but I know Makalika, and therefore joined this call so I could be a better actionable ally for Indigenous people. And as an IP transactions lawyer, I would love to help support and provide that type of legal aid and learn what I can to help support that community. So I'll just put that out there.
Thank you, Sarah. I'm so glad you're here.
Mahalo. Yes.
And Sierra, were you able to come off? I know you had your hand up and I thought you came off mute, but then I couldn't hear you.
So I think in the chat she said it was an accident.
Ah, okay, okay. Riley?
Aloha, and thank you so much for absolutely everything today. I am a settler here and have recently been and I also don't have much experience on the legal side of things, but just something that's come up in conversation with my partner and I. Is there any chance legally that there could be a price difference in goods on Hawaii, like a Kanaka price, a settler price, and then a tourist price? Or if that type of framework just hasn't been considered or isn't really possible to exist, or your thoughts on that?
Sort of beyond IP, just sort of in general.
But they do have the Kama'aina discount, so I guess that could be, but any tourist can use that. Even though they cannot say, that should probably be a rule. If you can't say Kama'aina correctly, you can't get the discount.
It's true.
Sorry. I'm from Kauai. We have people that look for ha'ena and they call it hyena, and I'm like, we don't have those animals here. That's in Africa. But
although you know what's funny, so I'm here with people from my staff, and not everyone's been to the Southwest before. And so my colleague, as we were driving, and he's from Waimanalo, we had to stop the car twice. Once because there was a rabbit, and the second time because there was a raccoon that we thought was a cat, but it was a raccoon. And the raccoon part actually made it more exciting. So, so we all get wowed by different animals.
Yes.
I think Tara has a question.
Hinakakem Herimba, aloha. Coming to you from the homelands of Shiriptui, which is the most southern pueblo here in New Mexico. And so definitely want to welcome your speaker to our homelands, and glad that you are standing on sacred ground. And if you look to where the sun sets, that whole horizon, there are volcanoes on the horizon going all the way north, and each one of our respective Pueblo communities connects and respects our volcanoes. So just making those relations too of sacred land. So you're far away from home, but you're kind of close and connecting that way. So just want to welcome you in a good way. A question that I have is about intellectual property and Indigenous nations interacting with journalists. A lot of times journalists want to parachute in, come in, get information, interview a bunch of people, and just curious your thoughts on some of this that maybe you've seen, where maybe journalists need to be better at thinking about intellectual property. Indigenous nations here on the continent, some of them have IRB things set up, but journalists, they're coming in, they have a deadline. And so I think that's something I'm just curious to get a view from you all. And I think the thing that's really made me focus in on this is the issue of missing and murdered Indigenous people, where a lot of people are wanting to come in to communities to get information. And so I'm just curious, any thoughts on any of that?
Devin, do you want to react? I do have reactions, but I don't want to take all the airtime. Okay. So
I was just gonna say that that all my interact, because most of the journalists that come to where I am at are Hawaiian journalists, so they know how to, I haven't had a crazy journalist yet, so I don't know what that interaction would be like.
One thing that I think about is the role of IP law and then other kinds of rules, right? So one of the things that I think sometimes gets well, just doesn't quite make sense to me is that in the Native Hawaiian community, there would have been rules historically, but there's also just customs and expectations, right? And within a discipline, whether it be kumuhula or any other discipline, there's also sort of industry expectations, right? Industry rules. And those kinds of concepts exist in the Western world as well, right? Like there's all kinds of things. Like, for example, journalists have standards on things they do and don't do, right? Like they generally, whether the law forbids it or not, they're particularly thoughtful about the way that they feature public officials' children, right? Out of respect, more than anything else. It's a respect, it's a courtesy. So one of the things that I think about too in this space is like, sometimes there's an IP question, issue, opportunity, but other times there's also just how are you thinking within your discipline about expanding your discipline's expectations, whether they be your ethical standards or just your traditions, customs, sort of discipline, your industry rules, to reflect some of these things, because that's how we would have done it in our realm as well, traditionally. And so this idea that like, oh, there's no analog. It's like, no, yes, there is. You've got all kinds of rules that you follow about what's respectful and the right thing to do. So part of this, I'm not sure that there's intellectual property call there, maybe, but what's more pokes out to me is like, what's the representation of Indigenous people in journalism, right? Like, because some of these things, like I'm saying, we've got part of our journey on IP is taking longer and longer and longer because we don't have representation, right? 15 culturally competent IP practitioners is not enough in a sea of 50,000 trying to serve, 11.2 million Native Americans. Like that just is not enough. So that's a huge problem. But it's similar when I think about some other disciplines that are sort of, also leveraging knowledge and things that are intellectually properly related, like the journalism industry. It's like, that's part of what my reaction is to that. It's like a call for, hey, there needs to be more representation of Indigenous people so that you can do better on this. Because if you had more representation, you would be doing better on this. And we can all advocate from outside of your discipline and try to ask for specific changes so that you're respectful of cultural expectations and norms. And honestly, maybe not even respectful from a particular cultural perspective. I mean, we might be talking about issues that are just respectful in any tradition, that aren't being respected because it's a disadvantaged community and you're just not being respectful even amongst your own culture's norms. But part of that is like, well, you're getting people who work from inside of that discipline to influence the norms, the customs, the industry rules are going to be more effective much faster. So it's sort of like this pervasive issue across all disciplines of lack of inclusion of Indigenous people. I hope that answered your question. Thank you so much for welcoming to your place. This is a beautiful, beautiful area. And I'm excited maybe on Saturday to go check out the outside. We've been mostly inside for the 2 days I've been here. Napua, I see your hand up.
Aloha. Wanted to mahalo Devin for his mana'o. And just here on Maui, appreciating as a kumuhula. I wanted to speak a little bit to the question and the comment that we just were talking about, and come in agreement that we do have control over who we speak to in the media. I know for myself, I have just refused to speak to certain reporters if I feel they're not sensitive, or at least have some integrity in reporting about culture. And so, yes, we kako'o support the Mahealani Richardsons, the Kanaka in media, and whenever she calls and wants to know about a story, I try to answer that call so that I can speak and give as much as I know of accuracy to the story, because I feel like the integrity of the intent is there. And I was listening to you, Devin, about this mana economy, and it rings so true as far as IP, because I know as a creator, we put our creations on a Merry Monarch stage, and it's there for the world to see. And there have been, competing in for 15 years, there have been times that I've seen some of my stuff elsewhere in other halal, or and I don't think I minded it so much, because there is also the mana'o of imitation is the best form of flattery. So sometimes I look at it and I go, oh wow, they must have liked it, it must have been good stuff, because they want to incorporate it. But I will say I do feel more like that when I see fellow Kanaka using it, like, okay, right on, it's something that they like. I think we could though use or benefit from an office, or what was it, a collective of people to kako'o Hawaiians with IP, because as you know, all of these things aren't just for Hawaii, but used in other nations to make lots and lots of money, like in Japan. And we've had some problems there, and it would be beneficial to our people, I know, to have that kind of support in international law, and how to solve those challenges, not just in the US, but overseas also.
Mahalo nui. Yeah, no, that's like, the imitation part, that's, just like hakumele, when people use a line of mele that is great, that is what, like in hakumele, that's actually what you like people to do, is to take from your mele so that it is perpetuated. You add to the treasure chest of of the Ike Hawaii, but it's that other part where it goes beyond imitation as flattery into abuse, and that's kind of what you're talking about, like how the people in other countries, they just take it all and they use it for their benefit. It's not for to give mana to the hula, or it's more to give themselves prestige and themselves mana. So that's kind of now what we got to do. Like that's the unfortunate, like we have, because of the abuse, we have to change, which we don't like to do, but here we are in this modern day of instantaneous information. I won't say it's maybe it's not Ike, it's not Naholowaʻa, that's for sure. Maybe, but we'll see. We gotta pick the correct Hawaiian word, because there's Ike and Naholowaʻa, different versions of information. Mana'o, everybody has it. Ike, you actually know it. Naholowaʻa, you smart.
One of the things that I think, if we could get more resources on this, is, people really love instant gratification, silver bullet solutions. This space isn't going to be like that. But I think that it's going to be something where you try a lot of different things and you see what works, and you kind of experiment a little bit. Like, okay, when you'll experiment with what you want to protect, what you can successfully protect, right? And this is not going to be one person necessarily. This is going to be a community of people who start really dipping the toe in the water of this space and saying, okay, like let's play with some things that we want to protect. Let's play with some contracts that we want to use. Because of course we still do want to share. You still want to have students, you still want to have workshops for temporary students, sort of a more, not necessarily in like a halal, but maybe you do want to still have one-time classes and things like that. So maybe you want to start using some contracts to like clarify expectations, do it in shared language and in a format that people understand who are not within the community. Maybe you want to try some licensing, right? Because you're saying, okay, when you get intellectual property, that doesn't mean that you can't let other people use it. It actually just gives you a lot of legal protections to control how it gets used. And so if a controlled process works for you and what you think is right for your art, then a licensing model probably makes sense. You don't have to charge money. or you can charge money to some people and not other people based on specific criteria. So there's just a lot of different tools in that IP toolbox. That's why there's 50,000 plus lawyers just in the United States that do this, and like thousands and thousands more in other countries, because it's not just like one thing. There's a lot of different tools within this system, just like what you expect when you look at real property, right? And you've got leases and you've got, you know, all kinds of complex development agreements and all those things. Like, really similarly, there's a complex menu of things that you can do with IP. And the Indigenous community is just going to have to, until we're doing it at scale, it's just going to be hard. It just feels very experimental right now because we're not operating in the space at a large enough scale for it to be been tinkered with, to us figure out, like, where are those things that, oh, that worked really well. Oh, you know, that kind of setup, you know, like you did this kind of copyright protection, you use this kind of, you know, simple one-page contract with your haumana, you do this kind of licensing scheme, you know, these kinds of things can start to click together and you start realizing, oh, that worked really well. Oh, that thing, that didn't work. That was a disaster, right? Like you start, but you just have to go through that process. And that's what everyone else does in the IP system too, but they've been at scale for such a long time that it feels really mature for some communities. And for our community, I think it's nascent. It's not yet mature.
I don't see any more questions from anyone. Last chance. Does anyone have a question? Otherwise, I think we are over time. Okay, any last words from our speakers?
Mahalo, everybody, for coming.
Thank you, everyone, for coming. This was a nice way to spend my lunch.
Julio.
Thank you.
I see there's an Alika, and I'm like, is that my daughter Alika, or is that other Alika? If it was my daughter, it'd be the first time she snuck into one of my talks, but that'd be pretty cool.
Well, somebody's asking if the presentation going. Oh, kahiahi, aloha. She wants to know if it's going to be shared.
It was recorded, so we can, yeah.
Okay.
So I think we're going to send an email after, maybe even asking for some feedback on, you know, if it was a useful presentation, and we'll have a link to the recording for people who registered.
I'm slowly learning how to use this Teams. Even though we've met on Teams many times, I'm like, oh, this is a different function.